Good afternoon, everyone, and welcome to today's webinar looking at eDiscovery in a reactive context. Before we start the webinar, we have a few small housekeeping points to address. To keep background noise to a minimum, we've placed you all on mute. We'll be responding to questions at the end, which you can pose at any time throughout the presentation using the chat function on the left-hand side of your screen. I'm Claire Stockford and work in the Commercial Disputes and Resolution Division of Shepherd and Wedderburn with a focus on international arbitration matters. I'm joined for this webinar by Alistair Brown, a solicitor in our Commercial Disputes Litigation team.
Good afternoon. As noted by Claire, in this final of our two-part eDiscovery webinar series, we'll be looking at the use of eDiscovery as a reactive tool. Now, we're going to use the terms eDiscovery and eDisclosure interchangeably in this webinar, as there's no practical difference between them. So before we begin, it's worth assessing what we mean by eDiscovery. We've coined this term to describe the comprehensive service we offer our clients to support their eDisclosure needs as a combination of the technology and the legal advice element. With businesses increasingly relying upon and storing digital information, the occasions where they need to retrieve and review sections of that digital information, typically called data sets, are becoming more frequent. However, there's more to the process than simply extracting the data set and viewing the data. When we refer to eDiscovery, we include all the elements necessary to complete an eDisclosure process, including the technology platform itself, technological support, project management, legal support and analysis, and any additional assistance required.
Often after a dawn raid, the commencement of an investigation, or when a dispute arises, we will be required to go through a disclosure exercise. The parties and their solicitors will be responsible for collecting and reviewing large volumes of data to ascertain what documents are to be disclosed to the regulator or other parties in a dispute. Today we will be discussing a number of potential uses of eDiscovery in a reactive context, specifically litigation and arbitration and investigations. And then we're going to look in a bit more detail at the process of eDiscovery from preparation to presentation. Finally, we're going to look at the future of eDiscovery, in particular the Jackson reforms and their implications, and the growing acceptance of eDiscovery as part of the disclosure process. So to look first at eDiscovery in the context of litigation and arbitration, this can be a lengthy process. In litigation, the court will usually stipulate what needs to be disclosed. Since the Jackson reforms, which I will come back to later, they can choose from a variety of options, depending on what suits the case. The Technology and Construction Court has an eDisclosure protocol that's a useful guide for all eDisclosure exercises, and I'd recommend a look at that. In arbitration, what is required to be disclosed can be specified in the dispute resolution clause itself, by the institutional rules that are to be applied to the arbitration, or ordered by the arbitrators. In a litigation or arbitration, the parties will almost invariably have come to some sort of agreement on the disclosure process, from the method to be used to extract the information, the person's targeted, keywords, and so on, with the court or tribunal resolving any differences. This can be quite an unwieldy process, but it's worth spending time on as it may help avoid issues and complications later. We at Shepherd and Wedderburn have been involved in numerous large-scale disclosure exercises, ranging from industries such as air cargo to financial services.
So turning now to investigations, what do we mean by investigations? Well, what we mean are investigations by the regulators, a number of European and national government bodies imbued with statutory powers to oblige undertakings to hand over information. So for example, you have the European Commission, think the recent investigation into Google, the Competition and Markets Authority, think the Energy Market Investigation, and Ofgem, Ofwat, Ofcom, think numerous investigations into suppliers of some of our key utilities. Their power to investigate comes from a variety of sources, from the TFEU on a European level to the Enterprise Act at UK level. More specific powers for the regulators can be found in legislation such as the Electricity Act or Gas Act. We have a depth of experience representing parties to these types of investigation and can therefore describe firsthand the impact the disclosure requirements can have. So, to give some context to the discussion today, we'll be using the following scenario based on true events as the backdrop to the webinar. So imagine you're a big multinational bank. You find yourself at the centre of a major scandal. Allegedly, some of your staff members have been in touch with personnel at other banks to try and manipulate the LIBOR rate. As you're probably aware, the LIBOR rate is an average interest rate calculated through submissions of interest rates by major banks in London, including yours. Your staff were meant to submit actual interest rates that they are paying or would expect to pay for borrowing from other banks. However, some staff members have been fiddling the figures, falsely inflating or deflating the rates so as to make higher profit from trades or to give the impression that they were more creditworthy than they were. You're now at the centre of a major investigation for fraud and for anti-competitive membership of a cartel. This may lead on to additional follow-on damages claims, which has the potentially severe implications. So how can eDiscovery help?
In examining the scenario that Alistair has just outlined, we're going to move through the life cycle of an investigation from conception to conclusion, as set out in the diagram that's now on your screens. So, in the scenario, you know the investigation is about to commence. You need to get prepared. How do you do that? First of all, you think about data management. Ensure a proper policy is in place for data retention and data destruction. This is important to allow for the smooth operation of the next phases of the life cycle. A key factor is defensibility. Your policy needs to be legitimate, reasonable, and thought through. There are a few considerations to think about here. Are there any specific requirements on your type of company? For example, law firms have Law Society regulations, telecoms companies have the Data Retention and Investigatory Powers Act, financial institutions have the Financial Services and Markets Act. What's the nature of the investigation? Will litigation holds be required to prevent any negligent or illegal destruction of relevant documentation? Various kinds of data management policy, from a save everything policy, which does what it says on the tin, to an automatic archive or expiry period for documents, could be used. Companies can also leave their staff responsible for the management of their own data.
It's worth bearing in mind that improper policy could lead to severe ramifications, as can be seen in this slide, such as costs in money, resource and time. There's also the potential for larger fines for loss of data, bigger for bigger volumes, as has been shown in a number of ICO cases. So in our scenario, the bank would want to dig out their policy and ensure that it was compliant with the relevant legal requirements on a financial institution, and if not, amend it without hesitation. Further than that, they would want to ensure that they had considered the implications of the investigation and whether it ought to inform its staff, and if so, which staff, of any legal holds that were being put in place. The importance of good data management can't be overemphasised, as it will assist majorly in the next stages of the eDisclosure exercise. Now, we're not going to discuss in detail how eDiscovery can assist in data management, as this was considered in detail in the first part of this webinar series. However, it is worth noting that eDiscovery can assist in the formulation of a data management programme, the electronic platform stress testing the system, and the legal advisors analysing and considering potential updates. It's at this stage, in the preparation, that a company may want to look to engage a provider. Essentially, the sooner the better, as failing to work in collaboration with an electronic platform provider will make the fight that bit more complicated. So now, in an ideal world, you have all your documents in a managed system. However, this process has brought to light the sheer volume of documentation that's held in the bank system. It'd obviously be nigh on impossible to go through all of the bank's documents and data to find the information the court or regulator may or already has requested. It will need to be narrowed down. You will need to identify who within the organisation holds the information you need, known in eDisclosure as custodians.
Initially, it's important when thinking about custodians to think about from whom you can gain the most information. In the bank's case, that's likely to be the traders. The traders were the nexus of the communications. They communicated with each other between banks and also internally within the bank. Therefore, by looking at the mailbox of a trader, you are likely to see much more relevant information than, for example, from that of a floor manager. Once the custodians have been narrowed down, it's useful to identify potentially relevant sources of information. In the case of an organisation like the bank, the obvious sources of information are emails and correspondence on handheld devices such as BlackBerries. These are likely to be relevant in almost every case. However, there's a wide range of documents that should be considered, including Word documents, PowerPoints, spreadsheets, instant messaging, and audio recordings. eDiscovery providers are highly experienced and will, with the assistance of legal advisors, be able to advise on what are the most common sources of data and where they can be found.
Now you've identified where the information you want sits. However, on personal computers, tablets, phones and filing cabinets, it's not easy to digest. The purpose of this stage is thus to acquire a copy of the data from the sources marked as potentially relevant in the identification stage so that it can be processed and prepared for review. So what sorts of things should the bank be thinking about at this stage? As can be seen from the slide, issues such as project management and data protection must be considered. Further issues such as completeness must also be borne in mind. A custodian may have multiple usernames and email addresses in different mailboxes or in other databases. Although this process of extraction can be done in-house, in our example by the bank, the involvement of an external eDiscovery provider can be beneficial for two reasons. Firstly, the eDiscovery providers are highly experienced in data extraction and are more likely to be able to obtain forensic copies of documents without causing any intrusive damage to the bank systems. This may be of particular benefit if the documents require to be extracted covertly, as the eDiscovery providers are able to enter the systems and image the user's hard drive and data without leaving any digital footprint behind. Secondly, by enabling a third party to obtain information, the bank will retain an air of impartiality. If they had extracted information themselves, it could be inferred that they had hidden or conveniently misplaced damaging documents and data to prevent them from going onto the review platform.
So we're now at the point where the data has been migrated onto the eDiscovery platform. The bank wants to know, at a glance, how serious the issue it is for the institution and get an overarching view of the wrong that has been done. However, given that the bank was required to hand over the data of a wide number of employees across the business, it's difficult to quickly analyse this to discover any specific and suspicious patterns of conduct. eDiscovery provides a helpful interim step here to assist in deciphering this massive data and to give the client a clear overview. We'll look in detail at a couple of examples of how this is done. The examples shown here on your screen are taken from the provider Stroz Friedberg, but there are other similar systems available on other platforms. So the first image shows concept clustering. The platform produces this wheel by reading and interpreting the entire body of every document in the review sample. As you can see from the screen, the wheel clusters the documents into general concepts based on keywords picked out of the body of the text. This can quickly identify large swathes of documents which are irrelevant to the review process and greatly cut down the time required to review the entire data set. The visual nature of the tool, combined with the intuitiveness of the platform, make it an easy way to get an overview of your documents and pick out potentially relevant themes. The second image that's appearing now shows communication mapping. The process is a simple yet effective way of gaining a snapshot view of employees' communications. As a first step, once the information is uploaded onto the digital review platform, each piece of data is designated a custodian, usually the originator of the data, for example, the person who created a document or sent an email. The platform then analyses all of this data and from this creates a visual and interactive communications map. This is a diagram showing in a concise and easily digestible form the instances where a custodian of a piece of data has sent it on to someone else. The frequency is denoted by the colour of the arrows, and you can drill down to look at the communications in more detail directly from the map. This can help bring to light any unusual patterns of communication that require further investigation. In the case of the bank, this platform could return some interesting results. It's possible, for example, that the map will show unusual and suspicious levels of communications between traders within the business or traders within your bank communicating with traders in another. This might assist you in narrowing down the search for perpetrators of fraud or cartel-like behaviour that's being investigated.
So once the data has been processed at a first glance level, it's now ready to be processed onto the main review section of the platform. In our example, the bank may already have been able to fill a substantial amount of data during the first glance stage, cutting out any document clusters that don't appear relevant. For example, because they brought up false positives, such as adverts, spam and news clippings. However, it's probable that a vast amount of data remains to be considered, and eDiscovery can help here. A number of techniques can allow the reviewer to cut down the volume of data that needs to be reviewed. For example, deduplication. One of the most effective and frequently used ways in which to reduce the volume of documents that require review. It can remove duplicate or near duplicate documents from a review set and will considerably reduce the volume of documents to be reviewed. There's also the use of keywords. At this stage, keywords can be used to narrow down the data set to be reviewed by limiting it to only documents containing that specific keyword or keywords. In our example, it can be imagined that the selection of the keywords would be a multi-party process, with input from the bank, its in-house and external legal advisors, the eDiscovery platform, and the court or regulator. At this stage, a wide range of keywords should be used to ensure that vital documents do not slip through the net.
Once the documents have been processed, they're now ready for review. At an initial stage, the documents can be placed in very broad categories, such as relevant and not relevant. This is typically a first stage review. At a second stage review, the relevant pool of documents can then be reviewed, with reviewers applying more advanced tags to these documents. These tags will usually be created by the same group that selected the keywords for sifting through the documents and can be amended as the review goes on. So there are various ways of tackling the review task. You could simply use a batch review, where documents will be split into batches of equal portions or by document families or keywords, and each reviewer, usually a junior member of staff of the external law firm, will review batches of several hundred documents for relevance. You could bulk review, where the reviewers will tag families of documents, for example, an email chain and all its attachments, in the same manner. And you could also use predictive coding. This is very interesting. It's a two-step process. The first step involves an expert reviewer manually reviewing a sample of the documents from the wider document pool and categorizing them as he or she thinks fit. The expert reviewer is usually an individual or small group of individuals who knows the matter well and the focus of the review in detail. It's therefore likely that this person will be able to accurately categorize the sample data. In the second step, the decisions made during the discrete manual review will train the review database and will extrapolate the expert's pattern of categorization across the entire data set. The database will create models or algorithms based on the content and metadata of the expert categorized documents, and these are then applied across the entire document set, categorizing all documents and highlighting those which are relevant to the case. It's worth noting that predictive coding can also be useful in reverse. Where there's no expert at hand, the reviewers may find it easy to categorize those documents that are definitely not relevant, such as spam flyers or subscription emails. This negative review will eliminate large volumes of data from the set, leaving reviewers with only the potentially relevant documents to review, saving time and money.
In our example, predictive coding could be very beneficial. The bank could select experts within their teams who would be able to easily spot the types of language likely to be used by the traders in their manipulation. These experts could work with the legal advisors and eDiscovery platform to categorise a sample of documents which, as described, will then apply across the full data set. In general, the following issues should also be considered when embarking on such a review. Firstly, you need to think about selection of the review team, both in terms of first and second pass reviewers, the size of the project, and the complexity of the data. Do you need expert reviewers? Next, training, both use of the software and matter training, including key issues and the scope of the disclosure. And you also need to consider cost and timescale considerations. The more reviewers, the higher the cost in man-hours, but potential savings in time. So you now have your reviewed batch of potentially relevant documents, but what if they aren't really relevant to the case? Even if they are, in what way are they relevant? What if they are confidential or privileged and cannot be disclosed? Here, the legal team, working in conjunction with the eDiscovery platform, can begin a proper analysis of the data. In our example, the team will be looking for evidence of anti-competitive and illegal collusion between the traders at the bank to manipulate the LIBOR rate. A narrative will be built through the analysis, showing who was involved, when it occurred, and what happened. The documents, along with the narrative, are likely to be what is produced to the court or regulator, so it's obviously important that everything that should be disclosed is disclosed, and everything that should not is not. This will include information protected by privilege. At this point, we'll go on in a little bit more detail on the point of privilege, which from our experience has caused a number of issues during the life cycle of an e-disclosure exercise.
So there are a couple of types of privilege to consider. The first is legal advice privilege. As most of you will be aware, this covers general legal advice whether or not litigation is pending or in contemplation. It also extends to advice given in a relevant legal context, but not to business advice or factual information. It does not cover communications with third parties. It will therefore only prevent disclosure of communications between the lawyer and their client. An important exception to consider is that in the context of EU competition investigations, in-house counsel correspondence does not hold privilege, even where it is purely providing legal advice. So the next type of privilege to consider is litigation privilege. This applies in respect of certain communications from the time that proceedings are reasonably contemplated. This has been interpreted to mean that litigation is a real likelihood rather than a mere possibility. And this type of privilege covers not only lawyer-client communication, but can also extend to communications with, for example, experts, if those communications are for the dominant purpose of litigation. This issue arises in the context of a disclosure exercise when certain documents are requested by the Commission, the Court or the regulator that the party believes are protected by privilege. There are a number of ways of dealing with this. For example, you can enter into agreements with the relevant body that certain of the information within the documents may be redacted, as will be discussed further on. In the courts, privileged information can be withheld. In EU investigations and regulatory investigations, there can be a concern that potentially privileged or confidential material may be passed on to third parties. For example, if it's requested from a public body via a freedom of information request. If the bank, in our scenario, asks the investigator to make a formal request, this obliges them to hand over the information, but should in most cases protect it from being passed on to third parties.
So going back to our scenario now, the bank, with the assistance of its legal advisors and eDiscovery provider, have extracted, sorted, reviewed and analysed the documents and are now in a position to hand these over to the authorities. But how? Well, your eDiscovery provider can also assist here. Depending on how the authority wishes to see the materials, the platform can organise the documents into a coherent structure and produce them in whatever fashion required. From our experience, some authorities, in particular the governmental regulators, still prefer a paper production of a company's findings, unfortunately. However, others are happy with disks or memory pens. Some are even happy to get access to the system on a limited access basis, and the eDiscovery provider can set different levels of security for different users. As mentioned earlier, it may be the case that some of the documentation is of a confidential or sensitive nature and requires redaction. Again, the eDiscovery platform can be of great assistance. Instead of going through the production with a black pen, the system can use certain techniques to make redaction easier. For example, bulk redaction, where certain names, figures, etc. can be redacted across the entire set. There's redaction by detection, detecting specific figures for redaction, for example, sort codes or national insurance numbers. And there's also inverse redaction, which is redaction in bulk, but detecting particular parts to remove from the redaction. So for example, when they're combined with or form part of another word. So in our scenario, it can be imagined that some of the documentation will contain customers' personal details, for example, account numbers and sort codes. The redaction by detection technique could be really useful here, sifting through the data pool speedily to redact references to such numbers. The data can then be presented to the authority in whichever form they've requested or has been agreed.
I mentioned earlier that I would come back to say a word about the Jackson reforms, and now I'm going to do just that. These were implemented on the 1st of April 2013 and brought major changes to the justice system. A key point that comes out of these reforms is that cases need to be dealt with at proportionate cost. There is now a proportionality test in disclosure which considers factors such as the sums in issue in the proceedings and the complexity of the litigation, among the others that can be seen on your screen. In terms of disclosure, the key message to take away is that the parties must have disclosure at the forefront of their thought process. They can no longer afford to add on disclosure as an ancillary part of a case, but it's something that needs to be costed and considered at the outset. There is a further key change from Jackson. There is no longer a presumption of standard disclosure. Now courts have the ability to choose from a menu of potential disclosure options, including dispensing entirely with disclosure, disclosing only documents on which a party relies, and request any specific disclosure from the opponent. This is commonly the process used in international arbitration. Another option is to disclose documents on an issue-by-issue basis or on a train of inquiry basis. Also, standard disclosure could still be ordered, and any other appropriate order could be made. The reforms stipulate that in making their decision, the courts must have regard to the overriding objective and the need to limit disclosure to that which is necessary to deal with the case justly. So what are the key implications for parties of these reforms? It is to prepare early and to budget. There is a requirement now to fill out an extensive electronic disclosure questionnaire and provide a statement of truth, except in exceptional circumstances. There's also a requirement to consider proportionality and cost effectiveness. And there are case management conferences at which the scope, timescale, search criteria and budgeting will be considered at length, usually. There are a couple of outstanding issues from these reforms. The rules are not as detailed as they might be, and there is a lack of guidance. And they mean that disclosure and case management are becoming increasingly complex.
So turning now to the future, the exponential growth of electronically stored data, combined with the ever more intensive disclosure requirements in parties, means that the courts and regulators are becoming increasingly comfortable with and confident in the use of eDiscovery and technology-assisted review, or TAR, as part of the disclosure process. A case in point is the Irish case of IBRC and others versus Sean Quinn and others. And the crux of this case was on whether predictive coding, as discussed earlier, was an acceptable means of reviewing documents for disclosure, given its reliance on technology. In his decision, the Justice noted that there was no specific rule in relation to TAR in Irish law, and that, in principle, time, cost and complexity should not be a barrier to discovering the truth. However, he acknowledged that even if the effectiveness of a TAR was deemed to be only equal to, and not better than, a manual review, the use of TAR would still bring cost and efficiency benefits. He further expressed that, provided the process has sufficient transparency, TAR using predictive coding discharges a party's discovery obligations under Irish court rules. The Irish judiciary has a keen sense of the cost and time benefits of using TAR, and while this is not a judgment of a UK court, it does illustrate the shifting attitude of the judiciary towards using technology where it helps to adhere to the principle of proportionality, particularly where an action is particularly document heavy. And it's anticipated that the English courts will take a similar view to that of the Irish courts.
Indeed, the Home Office has voiced some support for eDiscovery in its recent report on eDiscovery in digital forensic investigation. Although it noted that they do not believe that there yet exists an ideal tool to support the needs of both the technical and investigative elements of digital investigations, they did state that many of the eDiscovery tools assessed met many of the key requirements and could be a significant part of a combined solution. The Jackson reforms supported this further. Lord Jackson recommended that teaching on e-disclosure should become part of the CPD and learning requirements of all legal professionals, from trainees to judges who deal with disclosure. This suggests that e-disclosure is going to become an integral and ingrained part of our legal landscape. Therefore, anyone who feels they may be drawn into a litigation, arbitration or investigation should consider the potential impact the disclosure requirements may have on them and be ready to follow the life cycle of eDiscovery from preparation to presentation. Our key messages to leave you with would be: do not underestimate eDiscovery. Engage early with your lawyers and the external provider, and be prepared.
And with that, we can conclude today's webinar. Now, if you have questions at any time about e-disclosure or about our eDiscovery offering, we'd be delighted to assist. Please contact either of us for further information. And we also have a series of articles on the topic published on our website, which may be of interest to you or your colleagues.
But for now, we hope you've enjoyed this afternoon's discussion, and we hope to see you back at future Shepherd and Wedderburn webinars.